Good afternoon. Good afternoon.
Good afternoon, sir.
Where are you from?
Delhi, sir.
Delhi. Okay. Are you a first generation lawyer?
Yes, sir.
All right. There is another judicial officer by the surname Phutela.
Oh, I was not aware,
Okay.
sir.
All right. All right. Doesn't matter. Doesn't matter. Does the law of limitation destroy the legal right?
No, sir. The legal right is not destroyed. However, the time period for availing the remedy gets over by the end of limitation period.
Uh, uh, will you still stand with your answer if you were talking of Section 27 of the Limitation Act?
I'm sorry, sir. I'll have to read more on this. I cannot
All right.
recall at the moment.
Generally, you are right. Limitation does not destroy the right, but it only bars the remedy. But Section 27 is
Yes, sir.
one such provision. If you do not exercise,
Sorry, sir. I'll revise it.
all right. Just go back and read it again. All right. Uh, plea of limitation under Section 3. Does it cast a duty on the court to deal with the uh, suit even if no such no such defense of limitation has been raised?
Sir, I will have to revise this subject. Currently, I cannot recall. If I may make a recent estimation, it talks about the period of limitation in application and suits, but not in appeals.
Uh, all right. For your information, Section 3 deals straight away with suits.
Okay, sir.
It's
I'm
all
sorry,
right.
sir. I am yet to read on
All
this.
right. All right. All right. Can a suit be entertained after a period of limitation is over, prescribed in the schedule?
Sir, if the court finds a reason to condone the delay for the delay after the period of limitation, in that case, the suit can be entertained. The court has to be satisfied, however,
When did you pass out your law?
in 2020.
2020. Post that, what have you been doing?
Sir, I worked with EY in their contract drafting team for 10 months. Then I quit that job to prepare for judicial services. I recently completed my master's in 2024.
You see, suit cannot be entertained post period of limitation, expiry of period of limitation. It is only an appeal or an application which can be entertained post expiry of period of limitation, that too subject to showing of sufficient cause. All
I'm
right.
so sorry, sir.
All right. All right.
I will.
Uh, uh, what is the importance of pleadings in a civil suit?
Sir, pleadings is considered a very important document in a civil suit. It is the means by which the parties in written expresses all the facts that have been alleged by either of the parties. So, plaint is filed by the plaintiff and written statement is filed by the defendant. The provisions for pleadings generally have been provided in the um, Order 6 of the Code of Civil Procedure.
Okay. All right. Mm, are all the facts to be pleaded in pleadings, or there is a restriction on pleading what is to be pleaded?
Sir, all the facts relating to the cause of action can be pleaded. However, no evidence in that regard can be provided in pleadings.
Not only material facts have to be pleaded.
Some material facts and surrounding facts can also be provided in pleadings.
All right. All right. Can any evidence be led regarding facts which have not been pleaded, for which foundation has not been laid in the pleadings?
Sir, there is no general rule barring the presentation of such evidence, but if such evidence has to be presented, the court has to be satisfied that how this evidence will advance the case of a party. Otherwise, the court may reject for the argument by a particular evidence.
Suppose if I would say that without a pleading, no evidence can be led, and if evidence has been led in the absence of any pleading, that it will not be read by the court, would I be correct in saying so, or would I be wrong?
I'm sorry, sir. I will have to read more on this. I
All right.
limited knowledge.
What is burden of proof?
The burden of proof is um, the standard of proof required from a particular party. It may be laid on either of the party, depending on whether the suit is of civil or criminal nature. And burden of proof generally lies on the prosecution in criminal cases and plaintiff in civil cases. The idea is that the party on which the burden of proof lies has to establish their case before the court. Otherwise, their case would fail.
What is the standard of proof in civil and criminal cases? Is it
In
distinct?
Yes, sir, it is distinct. In civil cases, the burden of proof is to the level of preponderance of probabilities, and in criminal cases, the burden of proof should be beyond reasonable doubt. Standard of proof should be beyond reasonable doubt. Sorry, sir.
Beyond reasonable doubt.
Yes, sir.
All right. What is double jeopardy?
The double jeopardy has been provided under Article 20 of the Constitution, as well as Section 300 of the Code of Criminal Procedure. Uh, it means that no person shall be vexed for the same cause twice, thereby meaning that if a person has already been tried for a particular offense arising out of a particular cause of action, then he may not be charged with the same offense or any other offense arising from the same cause of action. So once a person has been tried and sentenced, then that person may not be tried again, even if the person has been acquitted in a criminal case.
Even under the Constitution and CRPC, uh, are you trying to say both these cover the same field, or
Uh,
do they deal with different fields?
Sir, both the
Suppose if
provisions,
all right,
yes, sir.
suppose if a person is tried and acquitted,
Yes, sir.
can he be retried on the same facts? Will that be barred under the Constitution? Is it in violation of the Constitution?
Sir, technically it is not a violation under the Constitution, but it will be a violation of Section 300 of Code of Criminal Procedure. That way, scope of Section 300 is wider than Constitution.
Scope of 300 is
Uh,
wider.
yes,
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 yes.
sir.
So all right, very good. Thank you. Thank you. My
Thank you.
time is over. Next gentleman will ask you.
Thank you, sir.
Okay, good morning, Bhavya.
Good afternoon, sir. How are you,
Good
sir?
afternoon. Okay, I want to ask you about can a plaint be rejected by a court of law or not? If yes, on what grounds? If not, why not?
Sir, Order 7, Rule 11 provides the grounds for rejection of a plaint by a civil court. There are six grounds mentioned therein. Grounds may be of the nature such as the stamp duty applied by the party is insufficient, or the valuation is improper, or no cause of action is apparent on the face of record, or it is barred by the limitation period, etc.
Also on ground of jurisdiction?
Yes, sir. Also on the ground of jurisdiction.
Okay. Okay, tell me, can a civil court pass a decree based on admission made by a party in the court?
Uh, y- I, uh, I I think, sir, it is permitted under the law. Admission is the general manner by which the court accepts any material before it. So when an admission is made, then a decree can be formed using that admission.
Is a court bound to pass a decree based on admission of a party?
So the court is not bound to pass a decree based on
It may
admission.
still require a party to prove whatever the allegations made in the plaint.
Yes, sir. Yes, sir. If a doubt appears before the court, then further proof can be sought by the court.
Okay. Okay. Tell me, an employee working in a pharmaceutical company
Yes, sir.
on the post of a clerk, and he's terminated by his employer. Can he challenge his termination before a court, civil court or labor court, or where?
So the contract of employment, if that contract provides the ground for termination, and termination has been given based on that provision of the contract, then it is valid. Otherwise, if any other ground or if the termination is arbitrary, then he can challenge that before court of law.
What is meant by arbitrary?
Arbitrary would refer to any decision which is based without any reasonable backing or reasonable logical argument. The argument is not logical or
Okay,
reasonable
let me
in that.
elaborate further. Suppose he's not issued any show cause notice before termination by the employer. Is it
Yes, sir.
arbitrary or not?
Sir, it may be arbitrary.
And where will
Uh,
he challenge?
So he can challenge before a civil court only on the grounds of breach of contract if the contract has been breached by such termination. For example, several times the contracts of employment require certain period of notice to be given both by the party employing as well as the employee. So if that notice period has been breached, then yes, sir, it would be a breach of contract or any other provision in the contract can be the basis of such
You are
challenge.
saying that he will have to file in civil court. Are you sure?
Sir, in my knowledge, if contract is involved, then the suit would be brought before a civil court.
But the employee who has been terminated was working as a clerk. Does he fit into the definition of a workman under the Industrial Disputes Act?
Yes, sir.
So is
I
there not a bar to jurisdiction of civil courts?
Yes, sir. It would fall under the respective tribunal. I'm
Yeah.
sorry, sir, for that. Yeah.
Because a clerk who has been terminated by the employer, there are special labor courts for this. He will have to
Yes,
go
sir.
to civil court. Suit is not maintainable because he fits into the definition of a workman. A workman has to approach a labor court, not a civil court. Civil court cannot entertain such a petition. Okay, there is a bar under the ID Act. Can you hear me?
Yes, sir.
So
Yes, sir. I lost you there for a few seconds. I can hear you now. Yes, sir. I think I
he
have
will have
erred
to
on my
approach
end.
a labor court, not a civil
Yes,
court.
sir.
Okay, that is
Sure,
one thing.
sir.
Suppose this clerk was a supervisor, working as a supervisor in
Yes,
the
sir.
company, then he was terminated in similar circumstances. Then can he go to labor court?
I'm sorry, sir. I think I will read more on this. Currently, my knowledge is not up to the mark in this area.
Okay, let me tell you that he can go to civil court against his termination because he is not a workman. Okay, supervisor is an accepted category. Somebody working as a supervisor drawing a particular salary can approach a civil court, and his petition in labor court will not be entertained. Okay, that is the distinction.
Okay, sir. Thank you so much, sir.
Okay, another question I will ask you. Suppose a foreigner tourist coming from Europe to India lands at Delhi airport, and she's wearing some jewelry, personal jewelry, say a necklace, gold necklace, and
Yes, sir.
she does not declare at the time of um, passing the the green channel, and then she's caught by the customs officer that she did not declare, she was supposed to declare, and a case of smuggling is filed against him before a criminal court. Tell me whether an offense of smuggling is made out against such a person.
Sir, a similar case reached the Supreme Court recently, and in that case, Supreme Court held that the items of personal jewelry that are found on the person, on the body of the person, those will not be considered the same as jewelry which are within the luggage and which has to be declared. So items of personal wearing may be exempted in that regard.
Can you
So,
give me that Supreme Court judgment which says
sir,
that?
I'm not able to recall the name at the moment, but this was a recent 2024 judgment.
Supreme Court judgment.
Yes, sir.
Okay. Have you heard of baggage rules 2016
Sir, I've
promulgated by
heard about
Customs
it.
Board? You have. And there is definition of personal effects given in the baggage rules 2016, and a jewelry item is excluded from the definition of personal effects.
Okay. Sir, I think I will read more. That judgment came to my mind because the facts were quite similar. And in that case, also the charge against the offender was that she did not declare the jewelry that she was wearing, and then Supreme Court had declared. But I will read more on this. Maybe I have something missing in my knowledge.
That's it from me.
Thank you, sir.
Good afternoon, Bhavya.
Good afternoon, ma'am.
Bhavya, is this your first attempt?
Ma'am, this is my second attempt. My first attempt was in 2022 cycle right after my graduation. I could not clear mains then. This is when I could
So,
clear.
do you regret not able to crack your first attempt or getting failed in the first attempt? Do you regret that?
Ma'am, certainly there is some regret, but I think my preparation was also not up to the mark then. So there were several gaps in my preparation, and there were few subjects that I had not prepared for seriously, and because of that gap only, I could not qualify the mains. I made sure this time that there are
Okay.
no gaps from my end.
Your honesty is much appreciated, Bhavya. So you will become a judge if you qualify this exam, right? So who is a judge,
Yes,
Bhavya? Who's a judge?
ma'am. Judge is any person who has the authority to provide a final judgment in.
Is it defined anywhere, judge? No
Yes,
issue.
ma'am. Judge
Hmm.
has been defined under the Indian Penal Code also, and Bharatiya Nyaya Sanhita recently also finds that definition. In
Okay.
these, judge has been defined to be a person who can give a final judgment or a final can sentence a person to punishment basically. And
Is judge different from magistrate?
ma'am, according to the definition that I was talking about, no. But in general, judge is a wider term than magistrate.
Is
A magistrate.
magistrate defined anywhere? If you know about that section, then you'll certainly know is there any difference or not.
I'm sorry, ma'am, I'm not able to recall at the
Okay, no issue. Do remember Section 3, Clause 32 of General Clauses Act.
moment. Okay,
Section
ma'am.
3, Clause 32 of General Clauses Act defines magistrate. So इसको
I
याद
will
करके
read.
जाना. Okay.
Thank you.
Okay, so judicial services. Is there any article which mentions about the recruitment of judicial services in the Constitution? Like under which article you will be recruited?
Ma'am, I am not able to exactly recall the article at the moment. It is
Okay,
300
is it
something.
234, 234?
Uh,
Is it?
ma'am, it's around there only. I am not able to recall the exact article. I'm so sorry.
No issue. Once you get done with your interview, to go through that particular article. Okay?
Thank you, ma'am.
Okay, Bhavya. Now let's come to Indian Penal Code. Okay? What is the difference between intention, objective, and knowledge?
Ma'am, I will start with objective.
Mhm.
Objective is any reasoning that enables a person to do a certain act. So, if a person is doing any act, it would be out of an objective that he may have formed at a prior point of time due to any circumstances. Intention would be the intent behind acting in such a manner. So, for example, if a murder is committed and A has murdered B, then any act which A has done to murder B would be said to be done with the intention to cause his murder. For example, if he is stabbing him with knife multiple times, so the intent can be called to be the intent to murder B in this circumstance. And
Knowledge.
knowledge, ma'am, knowledge would be any reasonable idea that a person might have that a certain act by him can result in a particular consequence. So it would be any by the standard of reasonableness, a person should know that what the consequences of his act could be. So that would be knowledge.
Okay. What do you mean by breach of contract, Bhavya?
Uh, Ma'am, breach of contract has been provided under Section 73 of the Indian Contract Act. Breach of contract basically means that from the two parties to a contract, if any party has failed to fulfill any part of the contract or the contract in its entirety, that would amount to breach. So,
Hmm.
if I may illustrate by an example, A and B have entered into contract where A would perform for B at any event, and B is the manager of that place. However, A fails to perform on certain days, so that would amount to breach of contract. B can claim damages as a consequence of this.
So rather, we should have said that section number 73 deals with the compensation on breach of contract, right? What are the remedies that you can have when a contract is breached? Is it only provided under Indian Contract Act or Specific Relief Act also? And what are the remedies if you can name some of them?
A specific relief act also, ma'am, provides quite a variety of remedies that a person can seek after a breach of contract has occurred. First would be damages only, which have been provided under the Indian Contract Act. The damages may be stipulated as part of the contract only, or the court may award them, whichever case it may be. Then specific relief can be enforced by the party if the provisions of Specific Relief Act are made out. Then uh, the Specific Relief Act also provides for remedies such as substituted performance or injunctions or any other interim relief or ancillary reliefs that may be sought after a breach of contract has taken place.
Is specific performance of contract also a remedy?
Yes, ma'am. I think it is a
Okay.
remedy. Specific Relief Act states that whenever a breach has occurred and the provisions are met, then court can enforce specific performance of a contract.
Okay. Can the contract based on personal qualifications, personal skills, be specifically enforced or be specifically performed?
No, ma'am. This has been provided under Section 14, if I'm not wrong, of the Specific Relief Act, that any contract which requires personal skills or any performance by the like nature by a party that cannot be specifically enforced.
What is the
If the
major
party has,
reason? What is the major reason for not enforcing such contracts based on personal qualification? Why?
ma'am, if I may illustrate by an example,
Hmm.
if the party who was supposed to perform a contract by singing, like in my previous example, and that person has not been able to perform, maybe say out of sickness, so he cannot be expected to sing. And in that case, because he was the only person who was supposed to sing, the specific performance of this particular contract cannot be
What if,
enforced.
no, what if I tell him that you take treatment, you take medicines, once you get fine, then sing? Why not then also we cannot, enforce personal qualification contracts?
Uh, Ma'am, in my limited knowledge, I believe it is because of the reason that court cannot supervise whether
Mhm.
uh, such after it has ordered the specific performance of contract, the court cannot personally supervise such performance of contract. It is because of this reason. But
Can we say that would be a violation of fundamental rights? Will it amount to bonded labor? Like, for example, you are a teacher. I compel you to teach at my platform. Will it not amount to bonded labor that I'm making you, forcing you to teach? And second thing, even if you come and teach, there will be no yardstick to measure your performance. How will we analyze that you are giving your best? Right? You may change your way of teaching. So these are the two reasons because of which personal qualification contracts cannot be enforced. First is it will amount to bonded labor. Second, there is no yardstick to supervise whether the performance was up to the mark or not. Okay.
thank you, ma'am.
And the last question for your interview is that can there be any situation in which for breach of contract you can resort to the remedy provided under Indian Penal Code? Can there be any section under Indian Penal Code where breach of contract is considered as an offense?
Ma'am, there is an offense called criminal breach of trust under the Indian Penal
Okay,
Code.
what if I am supposed to provide some wants to a needy person, to a helpless person, and I fail to provide those wants, those facilities where I was bound to perform or bound to provide those requirements to that needy person? Some 491. Remember section 491?
I'm sorry, ma'am, I'm not able to recall at the moment.
No issue, no issue, no issue. I think we can wind up with the interview and the panel will proceed to give you the feedbacks. Okay.
See, actually, earlier there used to be a requirement of active practice post law, because there are certain things which one can learn only while when one is in active practice. Theoretical to certain problems, you have responded well, actually. Uh, the example which ma'am was asking you and Pramodji had asked you, uh, theoretical, you said right when ma'am was asking you, but when it came to practical applicability thereof, you were not right when Pramodji was asking you. See, because contract of personal service, civil courts will not enforce.
Yes, sir.
Damages, yes. So reinstatement can be ordered by labor court, industrial tribunal, but not by civil court.
Yes, sir. That was certainly, I knew, I had read in the CPC also that cases before a tribunal would not go before civil.
So that
Yes, sir.
practical experience always helps you. Actually, I always used to think probably it doesn't. And Honorable Supreme Court had, by way of rules, also this necessity had been removed. But there is something which only only practical experience can tell you. But
Yes, sir.
overall, well done, and just your language expression appear to be good.
Thank you, sir.
They appear to be good. But all right, wish you all the very best from my side. Thank you so much.
Sir, if you can give me a suggestion on how can I better perform on these practice-based questions, where can I?
Only actual practice can help you. Once you
Yes, sir.
start going to the course with someone, get yourself enrolled, that will help you. Whether it is with a civil lawyer or a criminal lawyer, some practice there, some practice here. Actually, going to the course will add on, will sharpen your skills. Whatever
Yes,
you
sir.
have learned theoretically, you'll be able to feel the relevance of it only then.
Yes, sir.
How facts
Okay.
are pleaded, how evidence is led, what evidence, even if led, will not be read by the court. This thing, you see, there is a very subtle distinction. What we read, and when it comes to application, this is what actually matters.
Yes, sir.
Appreciation of evidence in courts is a very, very important facet,
Yes, sir.
which one can only learn by actual experience. But anyway, it's a good beginning. just keep it up. And whether one gets through, one doesn't get through, it has variety of factors there. So just keep trying, keep working hard. God will definitely help. Take care. God
Thank
bless
you,
you.
sir. Thank you.
Well, I have nothing to add. I completely endorse what has been stated by Padam sir. But Bhavya, I would say is good. She has good communication skills, and her general demeanor is also good. But learning is a continuous process, and there is always scope for further improvement. So I wish you good luck and my best
Thank you
wishes.
so much, sir. Thanks.
Bhavya, I completely agree with whatever Padam sir and Pramod sir have said. And coming to minor details, the way you have apologized for avoiding certain questions and not knowing is absolutely great. बहुत sophisticated manner में क्या है, expressions, attires, smile, confidence, too good. Now you might be worried about certain facts जो आपने पदम सर के सामने रखा, sir, how to improve my practical knowledge. Obviously अभी difficult हो जाएगा आपके लिए court जाना and everything. So basic, as you are running short of time. So the basic
Yes, sir.
thing that you can do is go thoroughly through the Berect. बहुत अच्छे से बेरिक पढ़ो, इन डेप्थ बेरिक को पढ़ के जाओ, बिकॉज आंसर सब कुछ उसी में छुपा हुआ है. Okay, keep revising the
Okay.
Berect nicely and don't worry about the
Okay.
fact that you don't know certain provisions from the Berect, you don't know certain applicability. It's absolutely fine to be sorry, but it's not fine to mislead the panel to act over smart, which you haven't done. So be confident about the fact, be honest. The more you will be honest, the better you will perform. Okay, बिकॉज जितना आप ट्रांसपेरेंट पैनल के सामने रहेंगे, पैनल आपको घुमा फिरा नहीं पाएगा. ओके,
Yes,
एंड
sir.
आई विश यू ऑल द वेरी बेस्ट एंड आई कैन सेंस कि सिलेक्शन हो जाएगा. सो गॉड ब्लेस यू.
Thank you so much, ma'am. Thank you, sir. Thank you, ma'am.